Good day to all of you. Today myself KAN Tilakaratna and DGCN Bandara from the Institute of Human Resource Advancement of the University of Colombo going to present our findings on is there a duty on states to prevent the spread of the COVID-19 virus, reflections on the applicability of international law principles on state responsibility. At the time of recording this, more than 217 million people have been infected with the COVID-19 virus. And it is rather unfortunate that nearly 45 million people have to sacrifice their lives because of the virus. Coming back to the presentation itself, the outline of the presentation is as follows. First, the background, the research problem, the objectives, methodology, findings and discussion, and the conclusion. As we all are aware, the COVID-19 pandemic that started in 2019 in the province of Wuhan in China has become a global pandemic which has not been seen in the entirety of human life. It might be an over exaggeration, still this is one of the most serious issues which threatens the mankind. Amidst this chaos, lot of things have been said and done. And in this research we tried to find whether there is any kind of a responsibility that would be casted upon a state to prevent the spread of the virus, especially outside its territory, and whether in the failure to take such preventive action could we find any responsibility attached to such a state under the norms of international responsibility of a state for its wrongful acts or omissions. Therefore, the main problem that we tried to answer in this research is whether the existing international law on state responsibility extends to the duty of a state to prevent the spread of the COVID-19 pandemic. And in order to answer this problem, we created three objectives that we wanted to achieve in our research. Firstly, to explain as to what is the current law governing responsibility of a state under international law. Then, to evaluate the application of the principles related to state responsibility during the COVID-19 pandemic. And to finally critically analyze the responsibility of a state in preventing the spread of the COVID-19 virus. In conducting our research, we used the qualitative methodology since this was a desk-based research, and the doctrinal approach was followed to answer the research questions. International legal instruments consisting of treaties, customary principles of international law, and soft law was utilized as primary data, and as secondary data we used scholarly books and articles related to the subject. When it comes to the notion of international responsibility, currently it is rather unfortunate to state that there is no one coherent single treaty that could be utilized to govern the law relating to responsibility of a state for the damages it may cause through its acts or omissions. So therefore, much of the law is still unsettled. However, there have been numerous efforts taken by the international community, and especially the one taken in 2001, where the International Law Commission was able to draft a set of articles on the responsibility of states for internationally wrongful acts. Apart from this, there are several other drafts such as the Diplomatic Protection Articles of 2006 and International Law Commission draft articles on responsibility of international organizations in 2011. And when it comes to the responsibility of a state, in the case of the Spanish Shores of Morocco claims, Judge Herber emphasized that responsibility is the necessary corollary of a right. All rights of an international character involve international responsibility, and responsibility results in the duty to make reparations if the obligations in question are not met. So when it comes to the spreading or the prevention of the spreading of the COVID-19 virus, we can find that the current notions or the current principles related to state responsibility can be utilized to hold a state responsible if they fail to adhere with taking the necessary steps to prevent the spread of the COVID-19 virus. For example, long before, in the case of United States versus Canada in the Trials-Milta arbitration, the arbitrators were very clear that in case where some kind of danger spreads from one country to another, the country which failed to mitigate or to prevent such kind of damage or loss can be held responsible. In this particular case, transboundary air pollution was regarded as something which will entail liability on the state which failed to prevent such. And there has been many literature written on the fact that there is no issue with imposing responsibility upon a state, especially if they fail to prevent the spread of the COVID-19 virus by taking the necessary actions to protect and safeguard their own citizens and also the citizens of the other countries. And coming back, when it comes to this responsibility, the implication or the implementation of the state responsibility can be seen as something quite problematic. The main reason for this is, as we all know, the international law works on the consent of the states. And when it comes to the topic of state responsibility, states have been very reluctant to adhere or to agree upon certain principles that are to be applied, because they are very jealous of their sovereignty and they are very much afraid that agreeing on an instrument related to state responsibility would be something problematic. However, when we look at the existing principles both under treaty law and customary international law, it can be clearly pointed out that the responsibility of a state to prevent the spread of the COVID-19 virus is clearly there, as it has a duty not to threaten the well-being and safety of other nations through its acts or omissions. And this can be easily enforced under the existing legal framework that is available in the international legal system. However, with regard to the enforcement of such liability, it will always become problematic, as the international legal system itself lacks a centralized system of legislative, executive and judicial powers, and this inherent weakness will also affect negatively upon the enforcing of the responsibility of a state to prevent the spread of the COVID-19 virus. So on a concluding remark, we can see that while the existing international legal norms are very much capable of preventing or rather enforcing the obligation of a state to prevent the spread of the COVID-19 virus, due to the inherent weakness of the enforcement mechanism that we find under international law, it may become quite problematic. So I thank you very much and I open the floor for questions. Thank you very much.